Good evening, friends. So today we had a quick switch of topics, and we have taken up a topic which became relevant a couple of days back because I have been working on this how to treat the data of deceased persons in the Information Technology Act area for a long time. We have been talking about wills and how the transfer of data has to happen after the death of a person, particularly when we are talking of data as an asset. And as you know, we are even saying as part of our PDPSI framework that the data should be valued in rupee terms, and then the organizations should have a mechanism to show the value of their data in their balance sheets. And even if the accountants have some difficulty in arriving at a common form of valuation of data, I have been suggesting that we should start by putting contra entries in the balance sheet. When you say contra entries, we will put the value both on the asset side and liability side, so it doesn't affect the profitability consideration. Nobody can accuse a company of overstating its profits or understating its profit. But the recognition that data has a money value has to be there in the balance sheet. Then only there will be a visibility. In fact, I think recently, we also came across an article which was posted by Subraidu that internationally also people have started looking at it. So what PDPSI has started will catch even with the accountants everywhere. So when we are talking of data as having some value, the problems arising out of a deceased person leaving data assets and his legal heirs not knowing the value of that asset is something which needs to be perhaps debated. In fact, even if you take people like us, for last 20 years, we have been working on in some form, writing something or the other and creating some websites. Basically, this is nothing but creating the sort of a data value which is there, and today there is no way that is recognized. In fact, recently in the courts in Tamil Nadu, we also had a discussion in the Jayalalitha case where there was this issue of inheritance of personal data. So I think from several areas, the discussions are converging on this aspect of the personal data with the deceased persons, how to handle it. Now, of course, we are looking at it from the perspective of the data protection. So the kind of issues which we will see is like when I am a DPO of an organization, and today morning I open the newspaper and see in the obituary column that one Mr. X has passed away. And I know that Mr. X is a customer of ours, some kind of a digital service, and our company holds his personal data either as a data fiduciary or in any other capacity. And it is also possible that I would have passed it on to many data processors. When in such a situation, I get this news about the person passing away. Now a thought comes to me of what is my responsibility in respect of the legal heirs of Mr. X, whether I have got a duty to inform them that so-and-so had an account with me and there are certain assets. Now I need to see how we dispose it off. If I don't do anything, it will just remain there, and perhaps after 3 years, 4 years, it will get deleted. So what action do I take? Is there an obligation first to protect the rights of the data principal after the death of the person? If so, how do we protect? if we don't have to protect it, why we don't have to protect it? These are the issues which are coming up now. And this is what I call as the data protection jurisprudence, which we have to develop now. See, when we talk of jurisprudence, there are many lawyers here. We always expect the judiciary to give jurisprudence. So we want cases to go up to Supreme Court, and then we say that, okay, court thinks this is the correct way. I don't believe that jurisprudence is born only at the Supreme Court, because it takes nearly 10 to 15 years for cases to go to the Supreme Court, as we have seen in the Information Technology Act cases, that for Supreme Court to come to a decision in a very important principle of law, it takes about 10, 15 years. And we cannot keep on waiting for Supreme Court to declare something after about 15 years. So jurisprudence has to be developed by cyber jurisprudents. And cyber jurisprudents are people who have expertise in the particular area, though they may not be officially the judge of a high court or a judge of a Supreme Court. Now, this concept or this thought has been in my mind for a very long time. And in fact, that is why in the cyber law area also, I have been saying that Naavi.org is focusing on developing cyber jurisprudence. That's why Section 65B and other issues, we have been in the forefront of placing our thoughts in the marketplace, and the courts have taken their own time to accept our views. The same situation will come in the data protection law also. The courts will take a long time to understand the complexities, and in fact, we in the industry are better placed to provide the guidance even to the courts on critical issues. One such critical issue is what we are discussing today. Cyber jurisprudence has to be developed, and we have to take the lead in developing the cyber jurisprudence. And at FDPPI, we are trying to set up an organizational structure for this, when we are setting up this courts committee to develop the personal data protection codes of best practice. It is issue like this which we have to look at. In fact, we have been discussing about this, how to transfer the assets of a deceased person in the case of death. And in the physical society, we know that there is something called a will. A person can write a will. Now, will can be written on any property, and that property can also be a digital property, which means that a will can be written for a digital asset also. But a will cannot itself be written in electronic form, at least in India as of today, because Information Technology Act does not recognize the document of will if it is written in electronic form. But you can always write a will in the normal paper form, and in that describe the digital assets as part of the assets. Of course, when we are talking of digital assets, we are talking of not only the emails and other things, but also your Facebook account and social media accounts. Imagine some photographer who have put a lot of photographs. There is a value to that kind of document, which is all lying around in the cyber space. A question also arises whether if will is not there, can there be a nomination? We know that in the financial world, we use nomination in the case of banks. In fact, Banking Regulation Act 45 ZA and ZB specify how nomination can be allowed for payment of deposits. Of course, when we look at nomination, as bankers, we know that nomination only means that the bank would be discharged from its liabilities by making payment of the balance to the nominee. Bank does not actually determine who is the owner of the bank deposit. In fact, the nominee gets the money and the nominee has the responsibility to settle the claims of other legal heirs. So legal heirs will be normally determined as per the Indian Succession Act, and if necessary, people will go to the court, and if the person has left a will, there will be an executor of the will, or the court may appoint an administrator or receiver or whoever is they think is going to handle the assets in a proper manner and hand it over to the legal heirs. So the system of nomination is working well in financial circles, along with the normal Succession Act, which determines how the inheritance of property works. Now the question is whether we can draw some kind of, I can say, lessons from the banking institutions and how they are handling the financial assets on death, not only in your SB and other accounts, but even in the case of, say, lockers. Now, there are cases in banks that the legal heirs may not know what is there in the locker. So if you just tell them, go to the court and get a succession certificate, they don't know for what property they have to apply for succession certificate. So there is a practice in the banking system where the potential legal heirs, that is those who still do not have the authority as declared by a court or by a will, we allow them to open the bank locker and take an inventory of the contents and then go to the court and get the succession certificate. Then the bank will allow the legal heir, whoever is decided, to open and take possession of the assets, which means that what is confidential between the locker customer and the bank, we open it out to the legal heirs so that legal heirs can have further proceedings to claim their rights. Now, whether such kind of a principle can also be used in the data related issues is a thought which I am trying to say we should think of. Now, we are having this intermediary guidelines under Information Technology Act. Now, one of the things this intermediary guidelines suggests is that the intermediary should periodically and at least once in a year inform the users about the rules and regulations, the privacy policy, and how the account is being run, which means that once every year, there has to be a communication which goes from the intermediary to the particular data owner. This is mandatory as far as the intermediary guidelines are concerned. In addition to this, whenever any complaints are made, the intermediaries are supposed to act within 24 hours and take reasonable and practical measures, sometimes to remove the content which is objectionable or something like that. And in the intermediary guidelines of the latest February 25 also say that the data is marked with a stamp, a visible mark as belonging to so and so. So there are certain guidelines which have emanated in the Information Technology Act. On the one hand, the will is not permitted, but then about the data which is being processed by an organization, we call them as intermediaries under the Information Technology Act, and we have certain provisions which say something about how the data has to be handled. Now, the question is, we will keep that aside and then see what happens when we have a situation of a death of an account holder. Now, if you look at the data protection regulations, first thought goes to the regulation like HIPAA, where whatever is called the PHI protection is extended up to 50 years after the death of the data subject. Remember that the personal representative of a health information under HIPAA has the general right about the deceased data, whom to authorize for access as well as disclosures. This is set in the law of HIPAA. Singapore PDPA also, we know, that recognizes the right of some of the rights on the personal data up to 10 years, because in the very definition column, Singapore PDPA defines an individual as a natural person, whether living or deceased. And then it goes on to say that personal data definition excludes personal data about deceased individuals who has been dead for more than 10 years. That is, more than 10 years, the data of a person who has deceased 10 years back is considered as non-personal data, which means that within the 10-year period, that is considered as personal data. So therefore, Singapore PDPA recognizes the right of an individual even after 10 years of death. Now, when we come to GDPR, however, GDPR clearly says in the recital that this regulation is not meant to be applied to personal data of deceased persons, though it leaves it open for member states to provide their own rules, which means that while HIPAA had already, because you know HIPAA is one of the oldest laws, 1996, from there itself, it has recognized the deceased data to be protected for 50 years after death. Now, Singapore PDPA is much later, 2012, and that has recognized 10 years. GDPR, however, has taken a stand that it is not applicable, and the Indian PDPA, to some extent, follows the GDPR, but it doesn't, as of now, specify exactly whether the deceased persons are excluded, and instead it is silent. Okay, it only talks about the natural person. And even Indian Citizenship Act is not clear about posthumous citizenship. In USA, there is a kind of recognition of posthumous citizenship, which is normally reserved for, say, defense people, but as a military honor. But even here, normally what is done is a deceased person who has done some great service to the country may be honored by giving him citizenship as on the date of his death, so that he dies as a US citizen, but that doesn't mean that after death he will get any more rights. So in the PDPB 2019, the preamble makes a statement that this whole legislation has been brought about because of the necessity to protect personal data as an essential facet of information privacy, because the right to privacy is a fundamental right. Now, fundamental right of whom? It is that of the citizen of India under the Indian Constitution. Therefore, the whole PDPB is directed towards protection of privacy of an Indian citizen. And since Indian Citizenship Act doesn't seem to recognize about this posthumous citizenship, there is a clear understanding that PDPB is not meant to protect the privacy of a deceased person. In fact, a deceased person, unfortunately, cannot claim the right to privacy as a citizen. There are, of course, debates many times, and one of the cases in which the debate went into the courts was Jayalalitha case, that there is an honor of a deceased person which needs to be protected. So therefore, disclosure of the information of a deceased person, there has been resistance in some way that it should not be disclosed just like any other information. But when it comes to the people in public, you can say, activity like Jayalalitha as a CM, there was a public interest in knowing about certain information. In the case of an ordinary citizen, that may not be there. But still, we know that the dead persons also have a right of honor, and therefore there has been some kind of restrictions on the disclosure of information. But this disclosure of information restriction is not to protect the privacy of the deceased person, but to protect the deceased person from being defamed. So it's a right against defamation, which normally we see when we say that a deceased person's information has to be kept private. For example, whether he died out of COVID or not, at least in the initial days of COVID, people didn't want to declare that the person died of COVID because it could have other repercussions on his relationship with all the people with whom he was interacting in the immediate past. But now I think that situation has changed. So people are openly talking about the cause of death. But there is one particular reason for which, if suppose there's a communicable disease, a person who dies of AIDS or something like that, there was, of course, a sense of feeling that it need not be publicized. But that was not to protect the privacy, but to protect against whatever may be considered as a possible defamation. So the PDPB, therefore, should be considered as an act where the definition of a natural person ends at the lifetime of the person. So the protection of privacy ends there. In fact, there is another reason why we should say PDPB has to consider only the living persons as being protected is that PDPB is totally dependent on the consent. Unlike some other laws like GDPR, where lawful basis can have other kind of things, the PDPB considers consent as almost the only way by which the processing of personal data can be done, though there are certain exemptions from consent, including legitimate rights and the rights of the government, but those are more like exceptions. Otherwise, the processing of personal data can be done only on the basis of consent, and that too free consent, which meets the standards of Indian Contract Act. Now, if you say consent is important, then after death, we know Contract Act does not permit a deceased person to provide any instructions. In fact, the instructions which he had given during his lifetime ceases to be effective, whether it's a power of attorney or any other contractual instruction. They cease at the time of death, in the sense once the notice of death is received, then any instructions which a person has received from that person should automatically be considered as not effective. Indian law is very clear that contract does not subsist after death, and therefore the consent also cannot subsist after death. And privacy right under the Personal Data Protection Act, being consent dependent, cannot subsist after death. This is my current reading of the PDPB. Now we can wait and see whether any alternate view comes forth when the PDPB is finally passed. But I feel that this will be the legal position as of now. Even if somebody, including a DPEA, comes up with an alternative viewpoint, I perhaps would still be saying that that viewpoint may not be correct. And since the objective of PDP laws, most of the laws, is to protect the privacy of the citizen, we always have to consider that it extends only up to the living period, and after that there is no privacy rights. But remember that the what privacy laws normally determine in terms of compliance, it has got two elements. One element is, of course, information security. Now, information security is what industry sometimes call as data privacy. That is, you give some value to the inanimate object called data, which is personal data, that is data related to an identifiable individual, and that data can be protected. That is, information security principles can be applied to personal data, and personal data in that context being inanimate object, a binary file, it doesn't matter whether the owner of that data is alive or dead. Therefore, information security aspect of privacy laws can effectively continue even after death, and that is what HIPAA has done. And even in the Singapore law, I think ultimately what continues is only the data privacy or information security. It is not the protection of privacy of the individual. When the individual himself is no longer there, obviously there is no question of protecting his privacy as a choice, because we say privacy is self-determination of the choice of how personal data can be used and disclosed, and that choice is expressed in the consent format. And when the individual is no longer alive, the value to that choice is completely absent. Now, the next question which we have to tackle is whether we should consider personal data as a property. In fact, this is what was discussed in, or is being discussed in the Madras High Court case, where there is a petition filed by Deepa Jaykumar, who is the niece of Jayalalitha. And she is claiming, of course, this was her petition arose because there were some movie makers who were using a certain life story of Jaya and trying to make a film out of it. And Deepa says that I have, as a legal heir to Jayalalitha's property, I have got a right against the personal information of Jayalalitha, and therefore I have inherited that property, and without my permission, then nobody should produce a film. This was the argument. This has actually been considered at the lowest level for granting of stay or not granting of stay by a single judge of the High Court, and subsequently appealed to the division bench of the High Court. But the division bench has refused to grant stay for that movie to be made. And in the process, the court has stated that definitive conclusions as to the posthumous exercise of the right to privacy and as to who can exercise such rights cannot be determined now, but they have kept a possibility that it may await the final disposal. But I hope that they will not come up with a bizarre decision that privacy right is something which can be inherited even at the next level, in which case perhaps it has to go to the Supreme Court, because in principle, I have a feeling that what can be protected is the inanimate object called data, but not the privacy right. And therefore, we should look at the deceased privacy in a totally different manner. In fact, Personal Data Protection Act, by defining the data subject as a data principal and data controller as a data fiduciary, has somehow implied that the relationship of the underlying or asset is not exactly similar to a movable or immovable property or even intangible assets. In fact, there is no reference to sale of personal data in Indian law like in CCPA. Okay. So what happens in the case of a personal data through consent is that somebody else can be given permission to do certain things or not do certain things with the data. That is all the data subject or the data principal can do. And it cannot extend to the transfer of the entire right on the subject data. So a data principal cannot say, this particular set of data, I am selling it to somebody else, the data fiduciary or the data buyer. If it was so, he would be called data buyer, not data fiduciary. So the Indian law by various means is indicating that we don't consider the personal data as property. And in fact, if you consider it as a property, then there are other issues. Of course, as I was already telling you, in the PDPSA framework, we have brought in the concept of financial value to be ascribed to data, which can be personal data or non-personal data. This was done because in the case of Net4 India, there was an issue of a company having been declared insolvent, though there was a valuable set of personal data with that company, which was valued perhaps at 100+ crores. And the company was declared insolvent for an NPA of around 100 crores. In fact, if the value of this personal data had been taken into account by NCLT, perhaps the company would not have been even declared insolvent. So there was that issue of ignoring the value of data asset. And that is why we have decided that there should be some way of bringing in visibility to the data as an asset. Otherwise, there is no point in calling data as oil and all those fancy names. So PDPSA has adopted this. In fact, when Chris Gopalakrishna Committee's recommendations on non-personal data governance come in, there is an indication that the non-personal data can be monetized or financially harnessed in a data exchange where there is a buying and selling of non-personal data in whatever packaging which can be done. But personal data still remains, even after Chris Gopalakrishna Committee's recommendations are accepted, personal data will remain as declared in the Personal Data Protection Act, and the possibility of data fiduciary selling the property, selling the personal data as property is unlikely to be recognized under the Indian law. And in fact, such a concept would adversely affect the privacy rights, since if you consider it as a sale, then right to withdraw consent vanishes. Say in the case of negotiable instruments, we have got a concept called holder in due course. That is, you can transfer the property in the data. Even if I don't have the right in the property, I can transfer it to the next person who can claim to be an absolute owner. So we cannot give such kind of special rights to personal data. And there is something called right to withdraw consent. And if you say that data is saleable, then the question of right to withdraw consent will have to be removed. So it is unlikely that personal data will be called property, though in the draft act, which was called DISHA, okay, Digital Information for Security of Health Information, that act, of course, is unlikely to be made into a law, but that act did have a provision to say personal health data is considered as property. But there the context was, when they declared it as health data, they were talking of data created by hospitals and medical healthcare industry, which is like the medical reports. And they had to distinguish whether that medical reports belong to the hospital or to the patient. In that context, they defined that health data is the property of the patient or the data subject. But anyway, that law is not coming through now. And the Personal Data Protection Act will also apply to the health industry. And therefore, this personal data as a property concept is unlikely to make any progress. In fact, Justice Sri Krishna himself, when he was discussing in one of the private seminars, somebody asked him why he called this data subject as principal and the controller as the fiduciary, what was the thought process. And he was trying to explain that the property of this data, even though we may say it is my data, my personal data, you cannot consider it like saying it is my house or my money kind of a thing. And he was telling that we can say my son or my daughter, but we cannot say that they are my property. Similarly, we cannot say personal data, which is mine, is my property. You cannot say that. There is something different, and that is why he introduced this concept of the data fiduciary. Now, PDPB also imposes something called right to correction. Now, what do we mean by right to correction? We have to keep it updated. Now, I told you in the Information Technology Act, there is this renewal of privacy policies once in a year. And maybe in PDPB also, we may have to use the same 1-year periodicity within which we need to seek correction by asking the person, please update your personal data. Now, the auditors who will do mandatory audit will also have to make a verification once in a year whether there is a control existing in the organization for ensuring accuracy, which means that do they have a system of sending these reminders at least once in a year to update. In fact, our PDPSI also incorporates this as a model implementation specification number 20 coming under standard 9. And the idea there is to have certain policies to ensure that you try to renew. Same way, you have the other issues in data processing area. One is when we handle legacy data. Now you have got a lot of data, and from tomorrow the PDPP comes. Now what do you do with your existing data? Now you will of course send a request for renewal of consent, and this is not just a renewal of consent, it's actually obtaining a new consent, because earlier consent, even if I had, it was not based on the same kind of notices which are required now. So every organization which is processing personal data will have to take fresh consent from the legacy personal data contributors. Then many companies also take data from publicly available sources, and that also needs to be reconfirmed, because we do not know for what purpose the person had made data public. And if I am going to use for a different purpose, we cannot simply use the publicly available data, whether from LinkedIn or somewhere else, and start processing it. We have to get a reconfirmation. Now, whenever there is a need for transfer of sensitive personal data out of India, there will be sometimes necessity where I have already taken the consent last year when I had my data center in India, and this year I want to move my data center outside India, and there would be perhaps a transborder transfer. Now I have to go back to the data subject or data principal and get an additional consent. So this reconsenting kind of a system arises on account of legacy data, publicly available data, and transfer of sensitive personal data out of India. And also because Information Technology Act itself says once in a year you have to renew. Now the problem or the challenge to the organization is, what if the data principal remains silent? He neither opts in and allows you to make use of the data, nor opts out expressly. In fact, many of them will be waiting to see what you will do with the data, and then perhaps come back and hound you by saying, I never gave you the permission to use the data. Why did you start using the data? So to use or not to use data when there is silence from the data subject is going to be one of the biggest challenges for companies who want to be compliant. Now, the other option which we can say is discard all this information. But for something which they have built as a data asset over a period of time and then spent hundreds of crores, as a consultant, if I tell them discard it, it doesn't make business sense. So we have to find a via media solution for such kind of a situation. Now we come to this deceased data. Now, one area where a person consciously withholds his response is a deliberate act of the data subject to keep you guessing. Now, let us say that 10% of the persons don't respond to you, and your data is, of course, accumulated over 5-6 years. You don't know, a majority of this data may be from deceased data principals. That is, though where you do not get a response, you have certain number of people who are actually deceased data principals. Even any number of emails you send to that particular person, you will not get response because nobody is opening that email. So this is one of the problems. Second, sometimes we may get a response from somebody claiming that he is a legal representative and he has got some rights or something like that. Now you have to take a decision of determining the claim of that person. Like in the bank deposits, we try to determine a claim. Now for digital assets, I have to actually determine whether this person is a proper person, or is he a hacker who is trying to claim data through phishing. Say, hackers are so intelligent that they will also be watching the people who are deceased from time to time, and they may even have, like the Nigerian mail kind of a scam. They can create a scam on deceased accounts and write to somebody who is having lots of data of that particular person and say, I'm the legal heir of so-and-so who has deceased last month, and I need all this data. So the data fiduciary needs to tackle genuine issues of people who are deceased and because of which responses are not coming, and also the demands from people whom you will have to determine the reason of how to settle a claim. Now, this is the typical situation which the PDP courts committee will have to consider and come up with its recommendations. See, I don't know whether DPA will come up with a code of practice for this kind of a thing. At least as of today, it is not in their radar. So now in FDPPI, because we have people from the industry and we can see this as a problem, I want our members to have some kind of a guideline on how to handle the situation of handling data of the deceased persons, and that is where our PDPCC is going to help in the development of data jurisprudence. And our DD MAC will perhaps take that idea forward by bringing it into some kind of an arbitration or mediation process, and thereby between this making of courts and a quasi, you can say, judicial decision of the DD MAC, we may be actually contributing to the development of new thoughts, which subsequently we hope will be also approved by the judiciary. Now, the solution, if you want to look at, I have tried to put in some of my thoughts, basically because of my experience in the banking scenario. And this is what I am trying to suggest, that when a requested demand for a consent renewal on any of the occasions, such as the periodical renewal as per the intermediary guidelines, or when legacy data has to be used or publicly available data has to be used, and we have tried to get the consent, but we don't get the response. Now, at that time, the personal data associated with it should be archived and transferred to a process through which we will determine whether it relates to a case of a deceased data principal, or it's a case of genuine apathy, somebody doesn't want to respond, or somebody is trying to get a sadistic pleasure by keeping the data fiduciary guessing, or perhaps raise some kind of a complaint sometime later. So we have to determine that this no response accounts should be considered as suspected deceased data principal account and initiate a process. What is the process I am suggesting? One is, as it happens in the banks, what we do in banks, For 6 months, if there is no transaction in the account, we call it as dormant. The moment it becomes dormant, certain security regarding access gets hardened, which means that the manager will have to approve or something like that. Then if it is not operated for 2 years, we call it as inoperative. Security becomes even more rigid. And if something is not claimed for another 5 years, it will go to the government, and maybe it will lie there until a proper claim is made. Otherwise, it will go to the Consolidated Fund of India. Now, the question we have to think is it possible to introduce a similar system, including the system of nomination? Now, one of the requirements for this is, I am suggesting that the Ministry of Information Technology should set up a personal data custodian who will act like the Consolidated Data Fund of India. And this unclaimed personal and non-personal data will ultimately go to this Consolidated Data Fund of India, and it could be considered there as a sovereign asset. If tomorrow there is a value to that asset, that value legitimately belongs to the government and not to the intermediary. Otherwise, the intermediary will hold it and make use of it. So similarly, we have to introduce a system that we send a request for response. If it is not received, let us say we send a second reminder. But if we don't get the response, then also we classify after 6 months the data as a dormant personal data, and then we transfer it to inoperative personal data store, and then transfer it to the consolidated data store. This is the kind of practice which I am recommending to be introduced as a best practice. Simultaneously, we should introduce a claim process for the legal heirs to claim the data, for which, just like a bank process, somebody has to prove that they are the legal heirs, and so it's quite possible that there could be a will which is also mentioning the digital asset. So whatever is that, they prove that they are the claimants, and they may come with a sort of order of the court or something like that. Then we can provide the information to them. And as I told you, like in the bank locker account, in certain cases, we may actually provide them some assistance to find out what is there. Now, for this purpose, one possibility is that we can identify a deceased account from out of public information, and we all are very proud of our artificial intelligence. So we can use that artificial intelligence algorithms to find out from information available over Facebook and other things to find out whether my client is dead or alive. We do it for marketing purpose. We can also do it for this purpose. Maybe somebody will actually generate a new AI algorithm for this purpose. Everywhere we invest money in data analytics to find out how much we can market to a person, but nobody has today invested money and time in finding out whether the person is alive or dead. Maybe the next generation of AI companies, startups will have to look at that. Now, whatever I'm talking of for these deceased accounts can also be extended to incapacitated persons. Incapacitation may be due to medical reasons. Sometimes it may also be due to contractual obligations such as insanity or even perhaps insolvency. Now, all these things you can see that some of these major intermediaries have tried to introduce some thoughts already. Google has got a policy which says that we recognize that many people pass away without leaving clear instructions, and we can work with the immediate family members. So there is an intention there, but there is no legal backing on how to actually develop a claim system. And I want to develop a claim system for data similar to what is there in the banks. Okay, in the banks, if there is a will, there is an executor of the will. There is a document which may be developed with the consent of the court, that if certain properties are not included in the will, you can have a separate provision to get court order. So something like that we have to develop for the data also. Twitter also has got a policy. In the event of the death of a Twitter user, Twitter says we can work with the person authorized to act. Now, the question we are asking is, how do you identify who is authorized to act? Because that is the claim process, which is a legal process, and somebody has to do it in a manner which is acceptable to the court. Sometimes the person may come with a password or something like that. So whether the deceased has given that password, we don't know. So we have to look at these things. Facebook also has got a policy, and they say that there's something interesting here, that they can appoint a legacy contact to look after what they call as memorialized account. Okay, and that memorialized account can remain in the Facebook account. Say, take the case of somebody like Abdul Kalam or somebody like that, who had a Twitter account or a Facebook account. A lot of thoughts he might have put in there, which may have a value for the subsequent population. And now those are the things which Facebook calls as memorialized account. Maybe it's a concept which we have to explore. But what they are saying is that they will retain that data with themselves. Just as the Tamil Nadu government said that they will retain that Jayalalitha's house as government property, Facebook says that I will keep that property with myself, which may or may not be the right thing. We have to see. So we are now in a situation where we have to find a solution to this problem. Problem is existing. I don't want to say that this is a time in which we are seeing more deaths around us, and this is not the reason why I am discussing this topic. This topic has been bothering me for quite some time, because somebody brought out a research paper on the handling of deceased accounts recently, Mr. Prashant Mali. I was tempted to open out a discussion from the Personal Data Protection Act, and that is why we are discussing it here. And now I would leave the floor open for discussions. If you have got any views, counter views, you are welcome.
So, here, so the digital will and any work in that direction from the government to prepare a digital will
requires a change of law. Okay. And considering that there is a lot of fraud possibilities, I don't know whether government will be moving fast on the introduction of digital will. Okay, you know the extent of phishing which happens, extent of hacking which happens, and if you say digital will is permitted, then there will be hundreds of digital wills which will be produced, and fraud management becomes an issue. So I don't know whether we should look for that immediately. Okay.
Okay. Yeah. Thanks.
Yeah. But digital assets can be willed in the normal paper will.
Naavi sir.
Yeah.
This HIPAA you talked about 50 years.
Yeah.
Any idea, sir, why they kept 50 years? And that too in 1996, when probably the digital media was not very highly active. Am I right? I understand in US a different way. They would have kept it in different hard disks or whatnot, etc. And any idea why they kept it for 50 plus?
One thing was, there was no concept of monetization of data at that time, to the extent we are talking of today. So there was no interest of the business to get it released. They only looked at it from the angle of the honor of the deceased, and in fact they said PHI will be protected for 50 years. Okay,
because of the health information.
Health information. Okay, I don't think they applied their mind in greater detail, and maybe it is time to actually rethink on
absolutely
that, because business may be saying that it's also required for research purpose also to some extent. Of course, even during the lifetime of the person, PHI can be released for research purpose as a limited data set, or de-identified data set,
20 hours.
maybe
Yeah.
that can still hold good even for the disease counts. But maybe it requires a rethink as of now.
I think with the kind of concept what you're talking about, the entire regulations across globe, including GDPR to whatnot, I think they have to really address this issue, in my opinion.
Yeah,
It has to come. You're right.
yeah.
And any ideas, sir, if you are aware, in GDPR perspective, any of the member countries, any of the region in European have addressed this deceased issue, like PDPB or
I
Singapore or
have not
something?
come across. Anyway,
Okay.
Kamal is here. If he has got any
Correct. Kamal, sir.
information, we can ask Kamal.
Yeah, hi. Exactly. First of all, very, very interesting and thought-provoking presentations. There are the principles are still consent given prior to death is believed to extend beyond death. You see, I mean, particularly that when one is intending to use tissue collected from the deceased person or at later on, regardless of what the relatives or the next of kin is saying. See, although legal details may vary from different countries to different, some basic legal and ethical principles apply in terms of consent required. So they might have taken the consent before, or if they haven't, there might be somewhere along the lines when a person might or might not have attended the hospital or something like that. So it's really thought-provoking, you know. And in simple words, what the GDPR is saying, that if a person if consent is not in place, and the person has not specifically refused prior to their death, particularly in England, Wales, and Northern Ireland. Sorry, I'm talking about very focused area. My apologies. An adult can nominate somebody to represent them after their death, to give consent on their behalf. Now, this has only come because of the GDPR. There was nothing such before, like what Mr. Naavi has already mentioned during the presentation, that is the applicability, the nature of personal data, and I'm glad in a way the way the PDPB in India is trying to impose various other specific issues, and one those which are like the right of correction, keeping people updated about. So is there a risk now when you were talking about the banks? Probably I find it personally as maybe after this presentation I might not think like that. I'm thinking that my bank is harassing me every like weekly. I get, can you update your KYC when I've already given them? They know I'm not in India, and whenever I go there, I go with my passport and all the relevant documents which is required. But I think if they say it's every 12 months, now the question arises, like you just said, a dormant account. That's what has happened because I haven't operated for the past 12 months, and it was a horrendous struggle just to activate that thing. You know, the number of calls, the number of emails, and every customer service representative is thinking differently. And so there is no like a fact sheet, you know, or like a giving a fact, follow these principles, you know, if a person is away or whatever. So I think you're right that whoever the person has written this document, you know, and that you are taking positive action, probably there is a learning. Or I might be sharing the same here with our group of DPOs and those who are within the ICO advisory group. You know, why is it, what is it, next principles? Every adult, like you touched on specifically around those who can't give consent, those who have got learning difficulties, people who have got also like the mental health issues, you know, particularly. And all those, the consent factor always has started to become quite big in a way. And there is always like the first question: has consent been taken? And they they have to sometimes use all the legal clauses like section so and so, section so and so under Mental Health Act or under the health, or trying to save somebody's life. So then the police can use their powers. So those kind of thing. I don't have a specific answer, because this is really thought provoking.
Yeah. Okay, great.
Yeah, Prakash, you have got any views on this? And Limaye, I think if he's there.
I think Prakash sir left, sir. He has to
Okay.
join another call. And sir, to answer this, Tripti Kumar, he had mentioned, the person had mentioned that Italy amended their data protection law for deceased person, and Germany did give a judgment as regards Facebook access in 2018 in case of a deceased person to the next of the kin. I understand. So there might be, now everybody will be looking at it, in my opinion. Yes.
Yeah. COVID will
Yes.
accelerate that, I think.
Yeah.
Yes, I can just add to that with Tripti here that this was regarding the accounts that Naavi sir mentioned about them being memorialized accounts. And access was cut off, and these parents fought, saying that, how can a private agency memorialize something that belongs to next of kin? And then I believe that Facebook had to grant access to them finally, because that still belongs to a person and it's personal data, and all the assets of a deceased, whether digital or physical, belong to next of kin legally.
Excellent.
Of course, subject to various conditions that Naavi sir also highlighted. As a general norm, a private agency cannot on their own decide what to do with someone's data when the law has not given them that power.
Yeah, excellent. Excellent.
Yeah.
But how about the liability? We are talking about only the assets. Whether liability also should be passed on.
Defamation is liability in law.
In banks, we recover the money first, okay, from the legal. But actually, there are many liabilities which don't pass on to the legal heirs. In India, we talk of actually honor of the family or something like that. But unless the loan was taken for the benefit of the family, the loan need not be repaid by the legal heirs. If I think Kodanraman himself can give his views on that. Yeah.
Yeah, I agree. See, now, whenever we go for recovery, the first obstacle is cannot be. In fact, in GST law, we brought specifically a legislation covering those sections, but still we are not able to overcome, because there are substantial laws which says a partnership has its limited liabilities to the partners, to the activity. So also to the company, your law, GST law cannot overcome that. That's what the courts have held. So therefore, when this kind of restriction is there, as far as liability of pertaining to an asset, how it can be more positively looked into. That's the thing first need to be considered. If there is liability for that company which owns those assets, whether they are ready to meet that, or somebody else has a liability on that, whether they are ready to accept it.
I think in FDPPI, we need to have a separate report developed on this. Okay, like we did for under Meena Lal's this thing, we developed one report, on the surveillance laws. Like that, I think somebody should organize. Mr. Kodanram, you can take the lead.
Sir, I am totally tired, sir. Today, without any this one, I simply rushed up and sat here because I have to study up to 15th. I am booked.
Some other lawyer should take the lead. Mr. Rangnath is there? I don't know.
Yeah. Sir, if time permits, I will add one thing.
Yeah.
See, now where this privacy is there, it's only individual centric. It's only to guard the fundamental right this has been awarded. This cannot be treated as an asset. Once the disease is there, then it is not possible for anybody to come in his place and take the role. There is no locus standi for anybody to take those rights into their hand, those fundamental rights. And therefore, I am of the opinion, these privacy, so-called privacy aspects, which are all data, they are not to be treated as assets, and they cannot be continued once the deceased is gone, because that right to claim that information, maybe information technology protection may be possible, but
Yeah.
not privacy protection as far
Yeah.
as this information is concerned.
Now,
Right.
Saurabh Singh, do you have any views, Saurabh?
No, sir. No, for now.
Okay. We will look at it as a thought which has to be debated, and we have the PDPCC to actually convert it into a policy if possible.
Yes, yes.
Potential policy which we can put it across to the
Saurabh Singh,
ministry
there
on
is
a
some
later day
Yeah.
and see. Okay.
Now, Naavi sir, only one quick input, clarification. Now, in as you covered in banking and etc. in everywhere, right? Nomination facility is there at the time of opening any account. Okay.
Yeah.
Now, even in the privacy, like Facebook or any other account, we are talking about digital assets. Probably now the new situation would emerge that at the
Correct.
time of you opening
That
an
is the
account, who
That
is
is the
going to
easiest way. That is the
absolutely.
easiest way.
No, I think it will emerge in my opinion, because that's the only way go forward. What you talked about claim process, okay, which is going to be, again, I need to go with the so much, etc., to prove myself as I'm the legal heir and whatnot. Probably this question would solve that, at the time of opening an account itself, I'm going to nominate.
It is in the interest of the data of fiduciaries to get a law on nomination
Absolutely.
done through
Absolutely.
PDPB itself. Now we have it right in our hands. If we want, PDPB can introduce one section which can take care of it. It will make the work of data fiduciaries easier.
Yes.
Say, like banks today are saying, we'll give it to the nominee, and if you have got any case, you fight amongst yourself for the next 20 years. Property cases go for hundreds of years. Okay, now Limaya has come back. I need Limaya's inputs.
Sir, I would like to work on it because this is very interesting topic, and as Ramesh mentioned previously, we should not refer to COVID deaths, but this issue will emerge because many people have lost their life, and if the matter is taken collectively through FDPPI, what happens about their data, etc., it would be an interesting debate. So I would like to coordinate thoughts on it as you suggested. And those who are in the meeting, they can share their views, and we can at least come out with some white paper or some sort of suggestions that will at least start some thought-provoking movement in the netizens. That's my suggestion.
Yeah, good. You please take the lead, and you please post one thing in the general group also about this, and let us involve others like our Meenal and other enthusiastic youngsters, lawyers. Okay.
Sure, sir.
Yeah.
Naavi, so I just have one point here you made on COVID-50 here. The point is also, there are some, I think I did read long ago, and I'll try and pull that out, especially matters relating to women who have aborted in the past and HIV data under HIPAA. These things have social impact for family which faces backlash once such data is released out in case. So adding to COVID as in under medical umbrella, I would also like that, these can be sensitive.
Absolutely. Very good.
Okay. Now, Tripti, you are talking about this contract post-death. Can you just
so in contract and type, because you did mention that contract rights terminate after death. I don't know if I understood the context in which you mentioned. I understand asset being separate from right. For example, my house is my asset, but my right of ownership is separate. Same way, my personal data is my asset, but my right to privacy is separate. So there are two overlapping.
My understanding is that any contract which becomes effective after the death of a person should be considered as a testamentary kind of a document. And of course, it can be done in paper form. There is no problem if law permits that. Of course, if it is done in electronic form, it becomes a digital will, which is presently not permitted. So that is one thing which we have to keep it in mind. But we can study this point which you have mentioned. So Lemay can take note of that also and see whether there is anything we can draw from there. Because ideally, The PDPA is an electronic activity. So people will not like to write down a stamped document and call it as a will and then add their Facebook account as an asset there. Okay. If it can be done on the account page itself in electronic form, that is the easiest way of getting things done. So there are practical issues, and of course, without amending the Information Technology Act, see if nomination can be introduced. See, even today, nomination in banking exists along with the Indian Succession Act. So similarly, nomination can be done for digital accounts by passing it under a law. In the banking, I think it has been done in the Banking Regulation Act or Nomination Act or something like that. So here also PDPB may perhaps be able to do it. Let us work on this. Maybe we will take it to the market by the time we have our next journal, Limaye, we should have a 40-50 page report on this.
Sure.
Naavi, sir, just one point. I completely agree with you, but 2 points I want to draw here. Just like every contract needs to be signed by a person authorized, the concept of consent is also explicitly authorizing somebody. So legally, I think it should be medium agnostic, whether digital or paper or whatever else comes tomorrow, cloud, or I don't know, so many other things which are intangible. I see your point in the way you are detailing the asset. That is right. I mean, that's a correct approach, I would think. But coming from actual execution, yes, I believe that, whether it's explicit consent or proper signature or valid execution, they are all synonyms of each other as regards a person's right.
But they expire on the death of a person, no, like this agency contract. The moment
no, unless, no, if I say that this will continue post my death, then no. Unless explicitly called out.
No, then it is a testamentary document. Okay, it is like a will.
No, sir. Section 202 allows that. That's what I said. Section 202 of contract law.
No, yeah. I think there is one thing in property where the agent has acquired some interest out of this contract. Then that will continue. Okay. That is, if you have given me a contract, and based on that contract, I have altered my position. Then the right of the person to withdraw gets affected. I think something like that is a special situation. But anyway, you are a lawyer yourself, so definitely we can go through it in greater detail later. Okay.
Absolutely.
Naavi sir, this is Nikhil here.
Yeah.
Just for a sake of see, anytime any medical information is said, what we say about the privacy, all the critical information, even we publish today our reports in the website, we have a filter situation where we know these are the critical parameters. It says you are HIV positive. That report would not be loaded if you are positive. Okay. So the public domain, when it comes, it is filtered out by the organization itself because there is an internal consent taken. Okay. So that is the way it is not coming to the forefront of activity that all critical informations are passed on. But coming back to the law and the privacy part is here filtered out when it is published in your website. Today you get a report in the website. If there is a critical parameter, it will not be published there. Okay, so privacy is somehow or other is protected. That's what we all do. But there is a definite consent taken by default, whether we understand or don't understand, put a signature and go. That is a lot of privacy things being given to a public domain saying, okay, we agreed upon, because that is in a panic situation. Otherwise, since we don't understand, we go, oh, how does it affect? Later stage, what comes to the contract and the fiduciary, and if somebody is dead, then there is for a lot of litigations, we are bound to give the detailed information. As a healthcare domain, I'm talking. I'm not a lawyer, not in the forum to say, how the rule has been amended. So that is how lot of complexity comes later on if it is a critical person, like a national, a politician, maybe a national figure person, or or something, like Jayalalitha case came in, everybody wanted to probe in and deep into, get into that, what is the clinical part and how it has happened, all those things will come.
Yeah.
So critical parameters by privacy, it is filtered out and not given to the public domain unless until the person itself or attender, maybe, the parents or somebody relative who has agreed and their mutual understanding is there, it is passed on.
Okay. Good. Anyway, this requires further discussion, I suppose, and thank Mr. Limay for having taken up the lead straight away and taking it further. Let us explore.
Sir, I would.
Yeah.
I would request just one liner here for us, because since I've been in healthcare, and can we have a place, can we have somebody who understands law and say, if we say this is the process where all it gets exposed to, the privacy is getting exposed. If we know those are our key controlling points, then we can say, okay, this is how the regulation should be, or this is how the documentation should be.
Sectoral guidance we will try to develop. Of course, you have what you said is filtering is something like de-identification. So de-identification and pseudonymization is a must kind of a control you have to implement. But behind that also, there can be a claim made later on. So you have to settle somebody's demand for information and look at the claim in its legal way. So you cannot escape the legal liability of identifying a claimant. But in the interim, for disclosures, particularly pandemic kind of a thing, it is in public interest you want to disclose. You can disclose de-identified information, or in HIPAA, what we call as a limited data set, which contains some identity, but that is, it is not fully de-identified, contains some limited data sets which are essential for the research purpose. So medical sector should develop that kind of a, sectoral guidance. See, what happens in PDPA is, being a cross-functional law, the DPA will talk of one guidance for all industries, but health industry may have to work out a certain exception. So we need to have that sector-wise some kind of modifications, and FDPPA would like to work on that. Yeah.
Right. Like TPA, third-party administrators, they get all information before approval. So they get the originals as well. So that is where you have a point, where it goes to somebody else.
Yeah, but that is also a data fiduciary, joint data fiduciary. Only thing is, you ensure that they remember they are joint data fiduciaries by mentioning that in the contract. Like in HIPAA, we say transfer from one covered entity to another covered entity is a permitted transaction. Likewise, your hospital transferring the data in its full form to the insurance agency is should be considered as an acceptable transfer. And in PDPA terms, you will be a data fiduciary. He will also be a data fiduciary, because his means of processing is different from your means of purpose of processing. So there will be joint data fiduciary status, and he has his own liability. But ensure that it is like when you sell a vehicle, you sign off the sale this thing, so that if any accident happens later on, you will not be held responsible. Likewise, in your contract, you ensure that when it is transferred, if subsequently something wrong happens with the data, that responsibility should belong to him. So you have to do some measure of control in that manner. Okay, I think we have taken enough time. So,
sir. Very quickly. Kamal sir, are you there? Kamal Acharya sir?
Yeah.
Please go ahead, sir. Thank you.
Okay, it's one of the most difficult tasks that you have given me, Mr. Ramesh, of thanking Naavi, sir. I was wondering why you were buttering me up, but never mind.
Kamal sir, lighter said, great, you understood. Go ahead.
Okay, I just wanted to say a huge thank you to Naavi, sir, taking us interestingly and intensively with the presentation with a lot of information, going through the journey of applicability, personal data, how it's dispatched, the nature of personal data, taking to the PDBB 19, how it's imposing the rights of correction, keeping updated other individuals, remaining silent, and also excellent suggestion about handling no response. Are we keeping people informed is the question to think about, and taking positive action of somebody's paper. And it's a very thought-provoking. In fact, I might be asking other colleagues here from the ICO to join future discussion as such, because it opens up a debate and also helps us all to shape what the governments are doing rather than individuals, because we need to give them the better guidance and direction. That's all I want to say. Thank you very much.
Great, sir. Thank you very much, Naavi, sir. Thanks,
Thank you.
everyone. Have a
We should-
nice evening.
You should have asked Srinivas to actually propose the vote of thanks.
I
Okay.
understood.
Fine.
Great,
Okay.
great.
See you.
Thanks, sir. Thank
Oh,
you.
my apologies if I missed something out, sir.
Okay.
No.
All right.
This is a different context. Thank you.
Yeah.
Thank you, sir.
Okay. All right.
Bye-bye.
Take care. All the best. Bye bye.
Yeah,
Have a
bye-bye.
good day. Bye.
Bye.